Welcome and thank you for joining Seyfarth's webinar titled Litigating California Wage and Hour Class and PAGA Actions. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. We will do our best to get everyone's questions. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Chris Crossman, who will begin today's presentation.
Okay, good morning, everybody, and welcome to our webinar. Before we get started, we're going to have to show you a disclaimer. All right, everyone got it? It's pretty interesting. Your presenters today are Michael Lafar, Chris Crossman, that's me, and Bailey Byfoss. You should feel free to call or email us with any questions that you may have, either regarding this presentation or any other labor and employment issues that you may want to discuss. Today, we have many exciting developments to cover. But first, we wanted to let you know that Seyfarth Shaw has just released the 22nd edition of the leading publication in the field, Litigating California Wage and Hour Class and PAGA Actions. It has been updated with many recent major legal developments, and we will be reviewing a number of them today. Now, some of these developments are actually so recent that they weren't included in the book before it was published. But don't worry, we'll bring you all the way up to date today during the webinar. The agenda for today includes recent trends affecting the Private Attorneys General Act representative actions, the California Supreme Court's recent decision, Naranjo versus Spectrum Security Services, which somehow made it even more difficult for employers in California who are faced with wage and hour lawsuits, pitfalls for employers to avoid in connection with properly calculating the regular rate of pay when paying hourly workers, and other key recent legal developments in wage and hour law. We'll also have a peek at key cases that the California Supreme Court is currently considering. Unfortunately, many of these recent developments are not that favorable to employers, but don't worry, we here at Seyfarth are ready to help you navigate your way through these treacherous waters. All right, so as I mentioned, the 22nd edition of Seyfarth Shaw's California Wage and Hour Class Action book has just come out. Yes, 22 years. We've been publishing this book since back in the day when folks were celebrating the dawning of the new millennium. And children who were born when this book first came out are now graduating from college. So there really are decades worth of defense-oriented legal analysis and advice packed into this one volume. We're going to show you the cover of the current edition. Here it is in a beautiful, eye-catching light purple. The book is free and available in a handy ebook format. We'll tell you how you can get your own copy at the end of the presentation. The book covers a veritable plethora of issues facing California employers in connection with wage and hour litigation, from expense reimbursement to meal and rest claims, unfair competition claims, representative actions under the Private Attorneys General Act, CAFA removals, class certification, next slide please, discovery issues, class action waivers and arbitration and settlements of class actions, all from a defense perspective, including strategy pointers and the case citations that you need to make winning defense arguments. In addition, the book has a handy statute of limitations reference section, which is on the next slide, to help you keep track of the differing time periods applicable to various types of claims. Next slide, please. And next, we also have a table of cases, an index of key terms to make it that much easier to find what you're looking for as well. Okay, now on to the recent legal developments and trends. First, I'll cover developments affecting representative actions under the Private Attorneys General Act. The most employer-friendly recent development affecting PAGA claims was also the biggest PAGA case of the year. And of course, I'm talking about the United States Supreme Court's decision in Viking River Cruises versus Moriana, which held that claims under PAGA could be compelled to individual arbitration. The Supreme Court's ruling partially overturned the California Supreme Court's decision in Iskanian versus CLS Transportation Los Angeles, which had held that categorical waivers of PAGA standing are contrary to state policy and that PAGA claims cannot be split into arbitrable individual claims and non-arbitrable representative claims. Viking River found that the Federal Arbitration Act preempts Iskanian's rule that PAGA claims cannot be divided into individual and non-individual actions through an arbitration agreement. Iskanian had held that an arbitration agreement that required an employee as a condition of employment to give up the right to bring representative PAGA actions in any forum was contrary to California public policy. But in Viking River, the Supreme Court found to the contrary that PAGA claims can be split. The court held that the individual PAGA claims of the named plaintiff can be sent to arbitration while the representative action remains in court. And as a bonus for employers, the court also noted that the plaintiff can maintain a representative PAGA claim only by virtue of also maintaining an individual claim in that action. And what this means is, therefore, once a plaintiff's individual PAGA claim is compelled to arbitration, the plaintiff lacks standing to pursue a representative action in court, and so the representative action must be dismissed. Now, Viking River didn't entirely overrule Iskanian. The Supreme Court stated that waivers of representative PAGA claims are still invalid under Iskanian if they amount to a wholesale waiver. So an arbitration agreement that requires employees to completely waive the right to bring to bring a representative PAGA claim are invalid. And in fact, the arbitration agreement at issue in Viking River did contain an impermissible blanket waiver of the right to bring representative PAGA claims. However, the agreement also contained a severability clause that allowed enforcement of any portion of the waiver that remained valid. Therefore, the court held that the employee's individual PAGA claim should have been compelled to arbitration, and then, because she no longer had standing after being compelled to arbitration, that her representative PAGA claims should have been dismissed. All right, Justice Sotomayor issued a concurring opinion, and she made some points foreshadowing that Viking River might be a short-lived victory for employers, unfortunately. She focused specifically on the issue of PAGA standing, and she noted that the Supreme Court's understanding of California law may be incorrect, stating that California courts, in an appropriate case, will have the last word. And this is because, of course, PAGA is a California statute, and standing under PAGA is a pure question of California state law, and therefore the California state courts have the final say, and not the U.S. Supreme Court. And indeed, the California Supreme Court recently granted review in a case called Adolph versus Uber on the question of whether an aggrieved employee who has been compelled to arbitrate their individual claims under PAGA loses standing to pursue representative PAGA claims. And we will hear more about that case later on in today's program. Justice Sotomayor also pointed out that the California legislature, quote, is free to modify the scope of statutory standing under PAGA, end quote. So the legislature, of course, could clarify the provisions for standing under PAGA and render the Supreme Court's interpretation moot. So what are the takeaways for employers in connection with Viking River? Well, most importantly, arbitration agreements may properly compel an individual employee's PAGA claim to arbitration. However, it is critical for employers to have the right language in their arbitration agreements. These agreements may not properly include blanket waivers of PAGA claims. And it's important to review and update arbitration agreements so that they conform to Viking River. And believe me, I have seen many, many different kinds of arbitration agreements since Viking River came out, and a number of them had problematic language in them. So a review of those agreements is critical. Of course, that's something that we here at Seyfarth can help you out with. All right, our next case is Hamilton versus Walmart. In recent years, employers have had some success in getting trial courts to find that PAGA claims were unmanageable, and therefore limiting or dismissing those claims. Last year, the California Court of Appeal, in a case called Wesson versus Staples, found that trial courts do have inherent authority to ensure that PAGA claims can be fairly and efficiently tried, and if necessary, they may strike a claim that cannot be rendered manageable. However, in Hamilton versus Walmart, the Ninth Circuit held that trial courts did not have discretion to dismiss PAGA claims that were unmanageable. The court noted that the concept of manageability arose from the statute, in this case Rule 23b3, and that PAGA had no analogous requirement. Indeed, the court found that imposing such a requirement would, quote, undermine the core goals of the statute, quote. PAGA is a law enforcement mechanism, and the state is not subject to any manageability requirement when it takes actions to levy penalties against employers. And so individuals acting as private attorneys general should also not be subject to such requirements. The court stated, quote, application of the Rule 23b3 manageability requirement in PAGA cases would be inconsistent with PAGA's purpose and statutory scheme and would not represent a reasonable solution to a specific problem. The requirement cannot be imposed in PAGA actions under the guise of a court's inherent powers. Now, this year, the California Court of Appeal reached the same conclusion for the same reasons in Estrada versus Royalty Carpet Mills. There, the Court of Appeal held that, quote, imposing a manageability requirement would create an extra hurdle in PAGA cases that does not apply to LWDA enforcement actions. This would undermine PAGA's purpose as an administrative enforcement action conducted in court on behalf of the state by an aggrieved employee, end quote. So there is now an active split between the 2nd and 4th districts of the California Court of Appeal on this issue. For employers, this means that PAGA manageability arguments may still be viable in California State Court, depending on which precedent your trial judge follows. All right. Next up, we have a case called Gavriloglu versus Prime Healthcare. In Gavriloglu, the Court of Appeal held that a plaintiff who loses arbitration on labor code claims still has standing to pursue a PAGA representative action in court based on the same underlying labor code violations. In this case, the plaintiff had filed an action alleging labor code violations as well as a representative PAGA claim based on those same underlying labor code violations. The trial court compelled plaintiff's labor code claims to arbitration and stayed the representative PAGA claims. In arbitration, the arbitrator issued a final award in favor of the employer, finding that the alleged labor code violations had not occurred. The trial court then granted a motion for judgment on the pleadings in favor of the employer. The court held that the arbitrator's ruling against the plaintiff on her labor code claims established as a matter of issue preclusion that she was not an aggrieved employee under the PAGA statute and that therefore she lacked standing to bring a PAGA claim. However, the Court of Appeal reversed, holding that issue preclusion did not apply because the plaintiff was acting in a different capacity in the arbitration and in the litigation of the PAGA claim. In the arbitration, she was acting in her own personal capacity, pursuing her own personal claims, but in the PAGA action, she was acting as the proxy of the state's labor law enforcement agencies. And therefore, because the parties weren't the same in the two actions, issue preclusion didn't apply. Another California Court of Appeal case, Howitson versus Evans Hotels, came to a similar conclusion, albeit in the context of claim preclusion instead of issue preclusion. In that case, the plaintiff filed an action against her former employer, asserting labor code and unfair competition claims individually and as a representative of a putative class, but did not assert a PAGA claim. That action settled and the trial court approved the class settlement. The plaintiff then filed a new action against the employer, asserting a PAGA claim based on the same alleged wage and hour violations as her first lawsuit. The employer demurred, alleging that claim preclusion barred the second suit as a result of the judgment in the first action. The employer argued that the plaintiff had strategically opted not to pursue the PAGA claims in her first lawsuit, that the two lawsuits involved the same or nearly the same alleged violations of the Labor Code, and therefore the plaintiff had violated California's prohibition against claim splitting. The trial court found that the parties in the first and second lawsuits were the same, that both involved the same Labor Code violations, and that because the plaintiff could have brought the PAGA claims in the first lawsuit, which ended in a final judgment on the merits, that would be when the trial court approved the class settlement, the state-based PAGA claims were barred by claim preclusion. However, the Court of Appeal held that, quote, claim preclusion does not apply because the parties in the two lawsuits are not the same. In the first lawsuit, the plaintiff was the real party in interest as she is an individual and class representative sought damages against the employer for purported Labor Code violations to employees. However, in the second lawsuit, the state is the real party in interest. Although the legislature gave plaintiff, as an aggrieved employee, standing to act as a representative in the second lawsuit, she was not the real party in interest in that suit. The Court of Appeal further held that the state was not in privity with the plaintiff because the state had no interest in the subject matter of the first lawsuit. Finally, the Court of Appeal held that the two actions were based on different primary rights. Quote, in the first lawsuit, the harm suffered was to the plaintiff individually and to a putative class of former or current employees for purported Labor Code violations to the employees themselves, in which compensatory damages were sought. However, in the second lawsuit, the harm suffered for such violations is to the state and the general public, in which civil penalties are assessed even if there is no injury to the employees themselves, end quote. Next up, we have Gunther versus Alaska Airlines. Here, the Court of Appeal held that the heightened wage statement penalties under Labor Code Section 226.3 apply only where the employer fails to provide wage statements at all or to keep required records. In this case, the plaintiff sought to recover PAGA penalties for inaccurate wage statements and asserted that the penalty should be $250 for the initial violation and $1,000 for subsequent violations. Labor Code Section 226.3 states that any employer who violates Subdivision A of Section 226 shall be subject to a civil penalty in the amount of $250 per employee per violation in an initial citation and $1,000 for subsequent violations. Labor Code Section 226.3 states that any employer who violates Subdivision A of Section 226 shall be subject to a civil penalty in the amount of $250 per employee per violation in an initial citation and $1,000 per employee for each violation in a subsequent citation, and this is the key part, for which the employer fails to provide the employee a wage deduction statement or fails to keep the records required in Subdivision A of Section 226. The civil penalties provided for in this section are in addition to any other penalty provided by law. Now in Gunther, the 4th District Court of Appeal focused on the language in the statute that says, quote, for which the employer fails to provide the employee a wage deduction statement or fails to keep the records required in Subdivision A of Section 226, end quote, and held that this plain language clearly limited the application of the higher penalty to circumstances where the employer did not provide any wage statement at all, or where the employer had failed to keep required records. Therefore, the plaintiff was not entitled to penalties at the higher amount because she was claiming that the information on wage statements was not accurate, but she wasn't contending that the Alaska Airlines had failed to keep required records, and it was undisputed that the airline had issued wage statements. Thus, the plaintiff was only entitled to recover penalties at the base PAGA rate of either $100 or $200. Now, this decision creates a conflict between the 3rd and 4th districts of the Court of Appeal. In 2018, the 3rd District held in Raines versus Coastal Pacific Food Distributors that, quote, Section 226.3 sets out a civil penalty for all violations of Section 226. Our next legal development is Hutchison versus Superior Court. In that case, a former employee sent a pre-litigation notice to the LWDA alleging wage and hour violations and then filed a PAGA representative action. 1 year later, a second employee of the employer who had also sent notice to the LWDA filed his own lawsuit based on the same alleged wage and hour violations. Shortly after the second plaintiff filed his lawsuit, he filed a motion to intervene in the lawsuit of the first plaintiff and to replace that plaintiff as the named plaintiff in the action. Apparently, the first plaintiff no longer wanted to serve as a representative. The trial court ruled that the claims of the second plaintiff could not relate back to the filing date of the first plaintiff's action because allowing relation back would frustrate the legislature's intent of requiring pre-litigation notice be provided to the LWDA before filing a PAGA action. Now, the Court of Appeal reversed, holding that the relation back doctrine did in fact apply. The court noted that the second plaintiff had sent a PAGA notice to the LWDA, even though later than the first plaintiff, and had filed his own lawsuit, again, even though that was later than the first plaintiff, and that the lawsuit was based on the identical claims. The Court of Appeal noted that the LWDA was the real party in interest, and so swapping one private attorney general for another was permissible. The court stated that, quote, to conclude otherwise would create a hurdle that impedes the effective prosecution of representative PAGA actions, thereby undermining the legislature's objectives. Our Supreme Court has made clear that allowing employers to reduce their liability for civil penalties without state oversight by curtailing a plaintiff's ability to pursue PAGA claims is contrary to PAGA's goal of strengthening labor code enforcement. The concerning aspect of Hutchison is that it would seem to make it possible for plaintiffs' attorneys to keep PAGA lawsuits going if it turns out that the named plaintiff is problematic for them. All they need to do is find another employee, send another pre-litigation letter to the LWDA on behalf of that employee, and then file a second lawsuit and move to have the second plaintiff intervene in the first lawsuit. Unfortunately, this fits into the general trend where defenses against individual named PAGA plaintiffs have very limited or no effect on the overall PAGA representative action. Okay, our final PAGA development today is LaFace versus Ralph's Grocery Company. That case confirmed that there is no right to a jury trial in PAGA cases. This is something we had long assumed, but this is the case that confirms that's true. In reaching this conclusion, the Court of Appeal resolved a debate that has occurred among trial courts at both the state and federal levels since the inception of PAGA. The Court of Appeal based its decision on several unique features of PAGA that make it unsuitable for a trial by jury. First, a PAGA plaintiff is merely a proxy for the state of California and brings what would otherwise be an administrative regulatory enforcement action on the state's behalf. And if the state had brought that enforcement action, the action would be subject to various rights and interests set forth in the statutory language of PAGA. And this does not include a right to a jury trial. So if the state doesn't have a right to a jury trial, then the state's proxy, the PAGA representative plaintiff, also doesn't have a right to a jury trial. Second, PAGA allows a court to award less than the maximum amount of penalties if, based on the facts and circumstances of the particular case, it would be unjust, arbitrary, and oppressive or confiscatory to do so. Therefore, the penalties recoverable under PAGA are subject to various equitable factors. And these factors require qualitative evaluation and weighing that are typically performed by judges and not by juries. Finally, the Labor Code concerns itself with a wide range of rights that were unknown at common law, such as suitable seating rights, wage statement requirements, and so on. Because these rights are novel and unknown at common law, they do not fall within the types of claims for which the California Constitution historically provided a right to a jury trial. So, considering all of these factors, the court concluded that a PAGA plaintiff does not have the right to a trial by jury. Okay, next up, Michael Afar will discuss the California Supreme Court's recent blockbuster decision, Naranjo versus Spectrum Security Services, which makes things even tougher on California employers who are facing wage and hour litigation.
Thanks, Chris, and thank you everybody for joining us today. As you've seen, PAGA claims and new cases on the PAGA sphere are definitely dominating the class and PAGA spectrum, but in that light, there is a new case that came out earlier this year in Naranjo that, on the heels of last year's Farah v. Lowe's decision, makes it even harder for employers to comply with claims stemming from meal and rest period obligations. So just by way of a little bit of case background on the Naranjo decision, if we can go to the next slide, please. Naranjo had filed a typical class action on behalf of all non-exempt employees in California against Spectrum, alleging that there was a failure to pay meal and rest period premiums, and that a failure to do so also resulted in the typical derivative penalties under Labor Code Section 203 for failure to pay out all wages at the time of termination or separation, as well as a claim under Labor Code Section 226 for failure to furnish accurate wage statements. In terms of liability, a jury had found Spectrum liable for a failure to pay meal period premiums, which wasn't really a disputed issue later in the case. The real meat of it was whether or not that failure to pay premiums then triggered final pay and wage statement requirements under Section 203 and 226. Next slide. The Court of Appeal reviewed that case and the lower court's decision and reversed the trial court. And the Court of Appeal concluded that the premium pay was a statutory remedy and was not a quote-unquote wage. And that distinction was all the difference in determining whether or not it could support derivative penalties under Section 203 or Section 226 for those penalties. Section 203 in particular requires penalties to be issued if an employer fails to pay out wages at the time of termination. And of course, if premium pay is not a wage, then it can't support a 203 claim. Similarly, for Section 226, the language of the statute requires an employer to list out all gross and net wages earned. And because the premium pay was not a quote unquote wage, then that could also not support the wage statement violations. Employers have relied on this Court of Appeal decision for a long time, which was a published case to reject employee claims for these types of derivative penalties based on meal and rest period claims, along with the attorney's fees that would inevitably come based on those derivative penalties. Next slide. And of course, what seems to now be par for the course in California, the Supreme Court reversed the appellate court, holding that violations of Section 226.7 for meal and rest periods do give rise to derivative penalties under Section 203 and 226. The court held that Section 226.7's premium payments are statutory remedies designed to deter employers from requiring employees to work through breaks, and that they're also wages that an employee earns by virtue of work performed during that break period. It also compared the premium payments to overtime wages, finding that both are designed to compensate employees for hardships, such as working more than 8 hours a day, and also to sort of shape employer conduct to act accordingly with what California wants as a more protective, employee-friendly environment. There are clearly parts of this decision that just don't make sense, even though we're still stuck with it. For starters, an employee who's working during a break, to the extent they claim that that time was work that was not otherwise covered because they were clocked out, seems to be more properly framed as an off-the-clock allegation, which is what we typically see from the plaintiff's side anyway, and they would try to seek unpaid wages for that time as opposed to some sort of premium pay that would be a separate penalty. And also the language from the court about hardships and shaping employer conduct points to a more punitive mentality, which indicates that this would likely be better as a penalty than as a wage. Nevertheless, this is what we're stuck with, and it's now clear that employers must include and separately list these meal and rest break premium payments on wage statements and ensure that they're all paid out at the time of termination or separation so that it doesn't give rise to a 203 or a 226 violation. Next slide, please. So other than that now clear language as to what employers are required to list out and include and pay out at the time of termination, the biggest open question is whether, one, employers can still assert affirmative defenses to these derivative claims for wage statement violations or final pay violations, and also whether or not this decision from the California Supreme Court is retroactive. On the first question on the defenses, I still think, and certainly we're advising clients that these types of defenses should be made. The California Supreme Court's decision does change and deviate away from what the Court of Appeal had previously announced in a published decision was the state of the law at that point. And so to the extent employers are facing derivative claims for penalties based on meal and rest period premium payments, then the traditional defenses of a good faith dispute or a lack of a knowing and intentional violation or a non-willful violation should still be addressed and argued in court as defenses to these types of claims. There's no case law yet addressing that point, mostly because Naranjo is a fairly new decision, but it's definitely something that we'll all be looking out for so that we can make those arguments on employers' behalf. On the question of retroactivity, judicial decisions are generally applied retroactively, but it was not explicitly stated in this decision, so it still remains to be seen. The Naranjo court did make clear that as early as April of 2007, in a prior case of Murphy, that it had pronounced that Section 226.7 premium pay is a wage designed to compensate employees. And what we've seen from the California Supreme Court in the past is that short of an explicit answer or decision from the California Supreme Court on a particular issue, they are willing to extend a new holding retroactively, and that employers should brace themselves for that sort of application in this case as well, if that's what comes up through the lower courts and appellate courts as well. And of course, why is this case such a big deal? As Chris alluded, it's a blockbuster because it can now trigger a huge amount of penalties that are at stake. Typically for these types of claims in class and PAGA cases, the underlying meal period premium payments or even unpaid wages are very small, and the amount of penalties are really what the tail that wags the proverbial dog. So it's something to keep an eye out for and to be mindful of, and to make sure that you're looking into your wage statements and your final pay practices to ensure that you're complying with the new Naranjo holding. Next slide, please. And while Naranjo didn't expressly hold or make any findings on the issue of attorney's fees, there was a court case that came out later in 2022 after the Naranjo decision called Betancourt v. OS Restaurant Services. And in that case, it decided the issue explicitly on attorney's fees. It held that Labor Code Section 218.5 does mandate an award of reasonable attorney's fees to the prevailing party in a claim brought for an action for non-payment of wages. And because Naranjo now has explicitly held that meal and rest break premium payments are quote-unquote wages, that would give rise to attorney's fees as well. This is also a pretty significant shift because historically meal and rest period claims were not fee-bearing causes of action. Attorneys would bring derivative penalty claims or unpaid wages claims to bootstrap their attorney's fees requests to that. But as expected, that case law has now changed, and Betancourt explicitly holds that employees can recover attorney's fees for violations of meal and rest period premium claims based on the Naranjo decision. And with that, if we can go to the next slide, I'll turn it over to Bailey to talk about some regular rate issues.
Yeah, hey everybody, and reiterating Michael and Chris's thanks for being here today. So you may have heard the term regular rate of pay thrown around. We're going to start out with some basics. What is a regular rate of pay? It doesn't mean regular as in normal, and it's not, or at least it's not always synonymous with an employee's straight time rate of pay. You all likely know that non-exempt employees can be paid in a host of different ways. You can pay them by the hour, you can pay them on a salary, you can give them commission, you can do piece rate, but the regular rate of pay is an hourly rate that has to be determined in order to calculate an employee's overtime rate. It's essentially a fraction, and it's calculated by dividing the employee's total remuneration for employment, with some exceptions, by the total hours worked for which the compensation was paid. So our numerator in this fraction is all the compensation that has to be included, and the denominator is the hours that are covered by that compensation. So think about it in terms of an employee who works just based on an hourly rate, right? Your employee makes $20 an hour, they work for 10 hours to earn $200. $200 is your total compensation. That's your numerator, divided by 10 hours worked as the denominator, gets you $20 an hour. Easy, right? So it's not easy. Spoiler alert, it's not easy. Here's where it starts to get complicated because things other than the hourly rate need to be included in the numerator, and not all of an employee's hours are always included in the denominator. So what about stuff like premium pay for certain hours, days, types of work? Things like shift differentials, commission, standby pay, hazard pay, all of that needs to be included. Think about a shift differential as an example for a second. Say you have an employee who works some hours at $15 an hour and some hours at $16 an hour. Do you pay their overtime at $22.50, which is 1.5 times 15, or do you pay their overtime rate at $24, which is 1.5 times 60? Does it depend on whether they work the overtime hours when they're on the $15 an hour shift or the $16 an hour shift? We're going to talk about it. Not included in the regular rate or in the calculation of the regular rate are the premium portions of an employee's overtime pay, premium pay for work on weekends, holidays, or other special days, so long as that pay is at least 1.5 times the employee's base rate. Now, what about bonuses and incentive compensation? What's in and what's out there? In our non-discretionary bonuses, seniority, longevity pay, attendance bonuses, generally anything that you're giving employees to encourage them to work harder, faster, more efficiently, that stuff typically is going to need to be included in your regular rate of pay. What's out? Discretionary bonuses, gifts, percentage of earnings bonuses, payments to profit sharing plans, contributions to employee benefit plans, things like that, generally not included in the calculation of the regular rate. And I want to pause for a second and talk about what constitutes a discretionary bonus, because this one comes up all the time. For a bonus to be discretionary, the employer generally has to retain discretion over both the fact and the amount of the bonus until very close in time to when that bonus is paid. So if you are announcing a bonus in advance, if you are calculating it pursuant to some predetermined formula, if you are tying it to a productivity metric, those are things that generally are going to cut against the discretionary nature of this bonus. And let me talk about bonus agreements for just a second, because if you are paying a productivity bonus pursuant to an agreement that says something like, but the bonus is discretionary, that's helpful. That's helpful language to have in your agreement. By itself, it's probably not going to get you there, absent other factors that actually make this bonus discretionary. One thing that's interesting about the regular rate area of law generally is that all of this stuff is primarily defined by federal regulation. All of you here probably know at this point that California likes to do things its own way, likes to make everything its own little adventure. So I'm going to blow your mind when I tell you that California mostly tracks the federal rules when it comes to the regular rate. Now, of course, it cannot fully leave well enough alone, so it has to make some tweaks here and there. In terms of calculations, the big difference in California is with respect to something called a flat sum bonus. I'm going to talk to you about that in a second. Folks who are paid on a piece rate or another production-based comp system like commissions are also treated a little bit differently. Also, under the FLSA, the Fair Labor Standards Act, the regular rate is mainly used for overtime and double time purposes. Under California law, you have to pay the regular rate for overtime and double time. You also have to pay regular rate for meal period and rest break premium payments and for sick leave. There's been some recent case law activity around regular rate in California in recent years. Alvarado is a decision from 2018. This is the one that really went for it with this flat sum bonus idea. Flat sum bonus is one that does not increase or have the potential to increase in proportion to hours worked. So attendance bonuses are a good example of this. Like you work every day this month, we'll give you $100. Sometimes retail facilities will have bonuses like this. Like if your store hits X metric, you get $1,000. Now, say you have a bonus like that. Your store hits whatever metric, we'll give you $1,000. The more hours you work, the lower the value of that bonus in your regular rate, right? Because the numerator in our fraction is staying the same, and the denominator, the hours worked, keeps going up. So the California Supreme Court in Alvarado said, no, we're not going to have that. When you have a flat sum bonus, it needs to be divided by the total straight time hours worked as opposed to all hours worked. It's complicated. I promise I will show you an example of it. We also have Sarah, which is a 2021 decision that we actually talked about in this presentation last year. It is the case that held that, whoops. It is the case that held that the regular rate must be used to pay meal and rest period premium pay, and this one does apply retroactively. So let's move on to the next slide, and we'll do an example. Let's do one with a shift differential. So in this example, Bailey works Bailey works 30 hours at $15 an hour and 12 hours at $16 an hour because of a 1 hour overnight shift differential, right? Graveyard shift, nobody wants to do that. We'll give you an extra $1 per hour if you work it. Step one is you're going to calculate Bailey's total earnings. You're going to do 30 hours times $15 an hour, 12 hours times $16 an hour. Don't worry about overtime yet. We're just doing straight time here. Gets you to $642. Step two, you're going to divide the total earnings by the total hours. 642 divided by 42 hours gets you to $1,529. Step three, you're going to calculate the additional overtime premium payment that is due. You're going to take that $1,529 and you're going to multiply it by half to get to $765. Now we're using the half-time premium here because the employee has already received straight time compensation for all hours worked, including overtime. That's why we're doing 0.5 here instead of 1.5 to get the overtime rate, right? Because the employee's already received the 1. They're just missing the half now. So we get to the 765 number, multiplied by 2 overtime hours worked in this pay period, gets you to an additional $15.30 of overtime owed, right? Let's do another one. With a flat sum bonus. Here we have Michael, who is working 42 hours in a week, 40 regular hours, 2 overtime hours, at a straight time rate of $15 an hour. Michael is also going to receive a flat sum bonus of $60 for the work done in that work week for a total of $690. See, I'm very creative in terms of naming the employees in my example. Here, Michael's employer is going to have to separately calculate his overtime premiums for his hourly pay and the flat sum bonus. So the hourly pay overtime premium is consistent with what you're all probably used to doing. $15 an hour times half gets you a $750 premium times 2 hours of overtime equals $15 an hour, right? Or $15 of total overtime during this pay period. Step two is where we're going to calculate the flat sum bonus overtime premium. Here we're going to take that $60 flat sum bonus and we're going to divide it by 40. We're going to divide it by the 40 straight time hours worked, not the 42 total hours worked, to get to a rate of $150 per hour. And here's where you see what the court in Alvarado was talking about, right? Because if you do the $60 bonus divided by 40 hours worked, you get to $1.50. If you were to divide that same $60 bonus by 42 hours worked, then the value of that bonus goes down. You're only getting $1.43 an hour. So that's why the Alvarado court made the decision that it did. So you've got your $150 an hour rate. This time we're going to multiply it by 1.5 times because we haven't already paid the straight time rate on the flat sum bonus, right? So we're paying the whole overtime rate on this flat sum bonus. So we're doing $1.50 an hour times 1.5 times 2 overtime hours equals an extra $3. So under California law, Michael is getting an extra $18 of overtime during this pay period. Under the FLSA, the total overtime payment would be only $15.72. Let's look at the next slide. So there's no hot and brand new case on this issue. It's hard, it's complicated, it's a lot of math. Bailey, why are you trying to break my brain with this math right before the holidays this year? I will tell you. Because this is an issue that often flies under the radar and it's having a whole moment in litigation. We're seeing a lot more of it in our cases. It's really hard to get right. Kudos to you if you have already checked with your payroll department and confirmed that it is being done correctly. It's really hard to do. It's also really easy to tell if it's being done wrong. Plaintiffs' attorneys are getting employee wage statements that reflect the payment of a shift differential or a bonus, and they're seeing overtime being paid at a flat 1.5 times the employee's hourly rate, and they're saying, that's a regular rate problem. It's also a claim that, frankly, is easier to have certified as a class or a representative action because there tends to be a uniform practice applied. There aren't as many of the individualized issues that we see with meal periods, for instance. One manager's doing one thing, another manager's doing something different. With regular rate, it's generally being run out of the payroll department, and it's either being done correctly as to everybody, or it's being done incorrectly as to everybody in the same way. It can have significant penalties. I mean, you think about the last slide, the example that we gave with the flat sum bonus. If Michael's overtime rate had been calculated using the FLSA rate instead of, or the FLSA method instead of the California method, he's only been underpaid in that pay period by $2 and change. The problem is if he's separated, he's going to be entitled to probably a few $1,000s in waiting time penalties. And he's going to seek penalties for the claim that his wage statements were wrong. And he's probably going to bring a PAGA claim. And when you multiply that over a few hundred or 1,000 employees, you start to get some big numbers. So what do we do with this? The first thing is don't assume that your payroll provider is getting it right. No shade to the payroll providers. This stuff is super hard, and it is the employer's responsibility to check and make sure that it's being done right. Second thing is do an audit of your payroll codes. We get it. Business is moving a mile a minute. What type of comp is being paid under what payroll code is the last thing on your mind. But we see this happen in litigation all the time. We'll get a regular rate case. We get an Excel spreadsheet that has every single payroll code that the business is using and what types of comp are supposed to be being paid under each payroll code. And it happens that there's a bonus code or a shift differential code that gets used for all kinds of stuff. Productivity bonuses are being paid under the code. Spot bonuses are under there. Bonuses to exempt people and non-exempt people are being paid under the code. Take a look at your payroll codes and really make sure that payroll knows what comp belongs under what code and what codes should be being factored into the regular rate. Or, because I'm totally shameless, hire Seyfarth to do that for you. But don't let this one fall off your radar because we are seeing it come up more and more in litigation matters. And with that, I'm going to pass it back to Michael for a discussion of other things we're seeing come up more and more.
Thanks, Bailey. Very easy for me to follow that regular rate stuff, so thank you for dealing with the math. This is our yearly potpourri section where we remind you of some other key recent wage and hour legal developments. And one of the benefits of joining us today for the webinar is that you get the benefit of seeing cases that have come out even since the publication of our treatise. And so if we go to the next slide, the biggest and most important case that has come out since the book has been out is the decision in Camp v. Home Depot. It's a California Court of Appeal case that came out very recently, and it deals with the issue of rounding, which is something that a lot of employers have been utilizing in California, hopefully not for long or not anymore, but it is sort of putting more of the writing on the wall that rounding may finally be dead, or that death is certainly coming in the near future. In Camp, the court considered the issue of neutral rounding, which has long been approved by California courts, namely in See's Candy back in 2012. And since then, in the last decade, the California Supreme Court has never explicitly rejected rounding. It's been considered in cases like Troster v. Starbucks and the recent Donahue case, but never explicitly denounced or rejected or held to be unlawful. However, the Court of Appeal in Camp held that employers who can capture and have captured the exact amount of time that an employee has worked during a shift must fully compensate employees for all of that time worked, rather than utilizing any sort of rounding, even if that rounding practice ultimately is neutral on its face and as applied. And that's what we see from a lot of clients, that they are capturing time to the minute and applying rounding sort of on the back end when they ultimately pay out employees for the time that they work. This decision is likely going to gain some more traction. If we look at the concurrence, which is probably the most troubling part of the case, is that the concurring justice wrote separately to explain why he believed that the majority's decision is a clear departure from See's Candy and sort of why that departure is appropriate. It basically lays out the roadmap for why rounding was never approved in California to begin with, why it impermissibly relied on federal case law and federal statutes rather than sort of applying the blanket California proposition of being more employee protective and favorable for employees. The court, in the concurring opinion, said, "I'm not persuaded that the California Supreme Court failure to expressly disapprove See's Candy is tantamount to an endorsement of that decision." And it takes us back to the retroactivity consideration. Again, the biggest concern we always have is, short of an explicit affirmation by the California Supreme Court on a particular wage and hour or employment practice in California, is something going to be applied retroactively or not? And certainly the Camp decision is trying to lay out a roadmap for the California Supreme Court to weigh in somehow in the future to explicitly reject rounding and to say that it was never acceptable under California. We certainly disagree with that retroactivity analysis. There's been plenty of opportunities for the California Supreme Court to denounce it, and any decision that might come down in the future would certainly be, should be a change in the law as opposed to a clarification. If we can go to the next slide, please. One thing I'll say quickly on rounding, though, is if you are one of the employers who is still rounding in California, we would highly recommend that you reach out and consider alternative options to pay employees for the time that's directly punched on their records as opposed to rounding. Even if you're able to round and show that it is neutral in application and in practice, the writing is pretty clearly on the wall now that a decision will likely come out in the future, if not already, with courts following the Camp decision, that rounding will be maybe held to be unlawful. So now we're going to the case of Magadia v. Walmart Associates. It's a case from late last year that considered an issue of standing and also some issues relating to wage statement violations. It's a good reminder that standing issues are going to play a large role in class and PAGA cases. Chris alluded to that a little bit in the Viking River decision, and sort of the importance of whether or not an employee had standing and how that impacted their ability to pursue other class claims or PAGA claims based on the arbitration agreement. We see it again here with the Magadia case. The Ninth Circuit considered whether the employee had standing to bring a PAGA claim for meal break violations that he himself did not suffer. And the Ninth Circuit said that at least under Article 3, that does not give rise to standing, and that the plaintiff did not have standing to bring the PAGA claim because he did not suffer any injury himself. There's also some good language in there about wage statement violations. Walmart had this overtime adjustment that they did every so often on their wage statements to true up employees for overtime based on non-discretionary bonuses that they received, and they would list that lump sum amount on the wage statement. The plaintiff had claimed that there was a violation because there was no corresponding hourly rate listed to that lump sum amount, and the Ninth Circuit held that that was not a violation of the wage statement law because there was no hourly rate in effect during the pay period for the overtime adjustment. And then finally, something that we see sometimes on final pay statements, typically where an employer terminates or an employee quits during a pay period, either right smack in the middle of it or at a point where it's outside of the normal pay run where they would get their wage statement. Here, Walmart had issued a final pay statement to the employee at the time of termination that did not have the pay period start and end dates on that statement of the final pay, and the Ninth Circuit said that that was not a wage statement violation. The language of California Labor Code 226 makes it very clear that an employer is required to furnish employees either semi-monthly or at the time of each payment of wages with that accurate itemized wage statement stub. And so an employer can choose to do it at either of those 2 points, either at that semi-monthly point or at the time of the actual wage statement payment or of the actual wage payment. And so here, because Walmart did not do it on their final pay statement, but did issue one later as part of their normal payroll run, had not violated the wage statement laws. Going to the next slide, this is a case of General Atomics v. Superior Court from late 2021 as well, and it addressed an issue that a lot of employers have had to face, which is how do we list overtime or the overtime premium portion on our wage statements? Some employers list it as both as having the 1.5x rate. Some employers have had it as just listing the 0.5 rate, and the California Court of Appeal held in a published decision that wage statements listing the 0.5 rate is not a violation of the wage statement laws. And so there are two tables that you'll see on the slide. Table 1A is the way that General Atomics had done it here, which is just listing the 0.5 rate. And table 1B is the what plaintiff said is the more traditional or required way of having the 1.5x rate. And so the court said that either version is acceptable. And so as long as you've got the correct rate amount for the 0.5 and you have the total hours worked there so that the employee can see that they don't have to double count, then there's no violation of the wage statement. And then finally, going to the next slide, a case that might affect some employers, likely not a massive issue, but something worth noting. A recent case, an affirmation of the Ninth Circuit on a lower court's summary judgment decision involving pre-employment drug testing. This is a case where the trial court had granted summary judgment against a certified class, saying that employee and class members were not employees when they underwent drug testing. And so even though the employees had to go and get, or these applicants had to go and get mandatory drug testing before or as part of the job application process, that was not considered compensable time, and that there was no control during that process that would otherwise make it compensable time. Similarly, those tests were not a condition subsequent to employment, but rather it was a condition precedent. And so now the moment that I'm sure everybody has been waiting for, if we can go to the next slide, is the CLE code. And that CLE code is SS, as in Seyfarth Shaw, 3661. Again, it's SS 3661. And with that, I'll turn it back to Bailey to talk about some important wage and hour issues that are being considered by the California Supreme Court.
Michael, I thought that you were about to say that the moment everybody was waiting for was the 2023 Cal Supreme Court section, and I was so flattered. But I'm gonna bring everybody home with a couple of anticipated decisions that we think we're gonna get in 2023 here. First one is Adolph versus Uber. You have heard lots about Viking River already today from Chris. He did a fantastic job. SCOTUS in Viking River held that employees who signed arbitration agreements could be required to arbitrate their individual PAGA claims and were thus barred from maintaining those individual or the representative claims in court. Justice Sotomayor, however, specifically wrote in her concurring opinion that this ruling, regardless of whether an employee who arbitrated an individual PAGA claim could still maintain a representative PAGA claim in court, was ultimately a decision of California law and a decision for the California courts. She specifically warned, quote, if this court's understanding of state law is wrong, California courts in the appropriate case will have the last word. California has wasted no time in deeming an appropriate case to take up, and they are going to decide whether California law allows an aggrieved employee who is forced to arbitrate her individual PAGA claim still has standing to pursue the representative PAGA claim in court. If California says, yes, this is appropriate, employers could be facing a two-front war in PAGA claims. You could be in a situation where you're defending against the individual PAGA claim in arbitration and the non-individual PAGA claim in court. Cross that bridge if and when we get to it. Next slide, please. The next case we are expecting to come down in 2023 is actually a Ninth Circuit case, but there have been some questions that have been certified to the California Supreme Court about what time is compensable. This is in the Huerta v. CSI electrical contractors case. And this case deals with some workers who generally drove their trucks down a long employer road where they had to follow certain rules, like driving a particular speed limit, I think, to protect wildlife. So the questions that have been certified to the Cal Supreme Court are whether time spent on the employer's premises in the personal vehicle waiting to scan their ID badge, have security guards look in the vehicle, exit the security gate, is that time compensable? What about time spent in a personal vehicle driving between the security gate and the parking lot while subject to certain employer rules, for instance, a speed limit, is that time compensable? And finally, whether time spent on an unpaid meal period when employees were prohibited from leaving the employer's premises pursuant to a valid CBA, is that time compensable? Going to get a decision on that in 2023. And the last case we're going to talk about, we also touched on briefly earlier, is this Estrada versus Royalty Carpet Mills case. In 2021, we had this great case, Wesson versus Staples, said a trial court can dismiss unmanageable PAGA claims. 2022, Estrada said not so fast, imposing a manageability requirement creates this extra hurdle in PAGA cases. It doesn't apply in LWDA enforcement actions. This isn't cool. This isn't allowed. California Supreme Court is set to resolve this this difference between the Wesson and the Estrada cases in 2023. And those are some of the big ones we're expecting to come down in the next 12 months.
Thank you so much, Bailey. Well, it looks like we are out of time. If you send us questions, we will try to respond to you via email. If you have other questions, please feel free to reach out to us. If you'd like to request our ebook, you can click on the link that we will be showing on the screen. And also, I believe all participants will be, or all attendees will be getting an email where they can do the same. Thank you, everybody, and we look forward to seeing you next year.